Today we are going to discuss about will deed. And who can write a will deed? Any person above 18 years of age can write a will deed. And will deed is a document that allocates the property that is self-acquired by the person to anyone of his will and wish. And this is called as a will deed. And this is nothing but the document that declares the rights on the properties after the death of the person who is writing the will deed. And it is not mandatory that a will deed should be written on a person of his own family. It is not mandatory that a will deed should be written on his wife or children or grandchildren or whatever. A person can write a will deed and allocate the property on anyone of his will and wish. It may be a temple, it may be a third person, it may be anyone, whoever he intends to give his property. And what kind of properties can be written in the will? Movable or immovable properties can be written in the will deed. And in the same way, what kind of properties cannot be written in the will deed? Property that is acquired from ancestral mode. In the sense, ancestral property cannot be allocated through a will deed to a third person or to even to the family members. Why? Because even they would be considered as a co-partners of the ancestral property. So that is the reason you cannot execute a will deed of ancestral property to which there are existing co-partners, and you can write a will deed on the property that is self-acquired by you. And what is a format of writing a will deed? There are few things which you have to keep in mind before writing a will deed. You should have the witnesses before you before writing the will deed. In the sense, the will deed should be written before the witnesses, and minimum 2 witnesses are mandatory for execution of the will deed. It is not mandatory that a will deed should be registered. A will deed can be registered or it may not be registered also. In case if it is registered, you have to go to registrar's office and register your document, that is will deed, before the registrar. And in case if you are not in a position to go to the registrar's office, you can obviously write a will deed on a paper or a bond paper, whatever, as per your will and wish. You can write the will deed, and that is equally valid as a registered document. And it is not mandatory that a will deed will be valid only if it is registered. But you should have the witnesses before the will deed, and you should be in a sound mind state before executing the will deed. And the will deed will come into force only after the demise of the person who executes the will deed. And the major clause that has to be added in the will deed is, you should mention that all the other will deeds that have been executed by me prior to this will deed stands cancelled through this will deed. This is the mandatory clause that you will have to incorporate in the document. It is always recommended that an executor should be appointed for a will deed. Who is called as an executor? Executor is a person, he may be your friend or an advocate or a law firm, whoever takes the responsibility of executing the will deed that is being executed by you after your demise. And he would be the key person to bring the will deed that you have executed on force. In the sense, he would hold the document of will deed and he would bring it to the force. And he is called as an executor. There are so many law firms today who are taking the responsibility of executing the will deeds. And another important point that you'll have to keep in mind is, will deed can be even cancelled, and will deed can be even conditional. You can impose conditions in your will deed stating that if you want to allocate a property to one particular person, you can say that this particular property can only be enjoyed by the person, but he cannot sell the property. This is one kind of condition which you may impose. Or you may also impose a condition such as, in case if they are taking care of you and your welfare, or your wife or whomever you intends to, till the death, only then the property which is written in the will deed will reach them after your demise. Even this is one of the conditions which you can impose in the will deed, which is commonly imposed by many of the people who executes the will deeds. So these are the important clauses that you have to keep in mind at the time of executing the will deed. And the most important thing that you'll have to keep in mind is, when you are selecting the witnesses before writing the will deed, you have to keep in mind that those people whom you are selecting and who are going to sign the document as witnesses of the will deed of yours should be ready to come to the court and give their witness. And this is most important. And in case if your will deed is being conflict in the future after your demise, or it leads to a litigation after your demise and it reaches the court of law, the person who have signed as a witness in your will deed should be ready to come to the court and render his witness before the court pertaining to the will deed and genuinity of the will deed. So hope this video is clear to you and it would help you in executing the will deeds. Thank you.